Welcome back to SCOTUS Oral Arguments and Opinions. This is the third of 4 episodes of today. In this episode, we'll discuss the June 26, 2025 Supreme Court opinion in the case called Gutierrez v. Saenz, case number 23-7809. Please note that this summary is read by an automated voice. In this case, the Supreme Court ruled 6-3 that Texas death row inmate Ruben Gutierrez has standing to sue state prosecutors in federal court for allegedly violating his due process rights by denying DNA testing that could affect his death sentence eligibility. The court held that Gutierrez adequately alleged an injury in fact and that a favorable declaratory judgment would redress his harm by eliminating the state's allegedly unconstitutional justification for denying testing, following the precedent from Reed v. Goertz. Justice Sotomayor's majority opinion established that prisoners can challenge state DNA testing procedures even when prosecutors might find alternative grounds to deny testing, as long as the lawsuit targets constitutionally problematic barriers. The decision allows more federal court challenges to state post-conviction DNA testing laws, potentially increasing litigation delays in capital cases while expanding procedural due process protections for death row inmates. In this episode, we'll break down the opinions in this case, starting with Justice Sotomayor's majority opinion and the competing views from Justice Barrett's concurrence and the dissents from Justices Thomas and Alito. Then we'll explore what this decision might mean for future challenges to state post-conviction procedures and the ongoing tensions between federal court oversight and state criminal justice systems. The question presented in this case is, does Article 3 standing require a particularized determination of whether a specific state official will redress the plaintiff's injury by following a favorable declaratory judgment? Justice Sotomayor delivered the opinion of the court, in which Chief Justice Roberts and Justices Kagan, Kavanaugh, and Jackson joined, and in which Justice Barrett joined as to all but partes third, B2. Justice Barrett filed an opinion concurring in part and concurring in the judgment. Justice Thomas filed a dissenting opinion. Justice Alito filed a dissenting opinion, in which Justices Thomas and Gorsuch joined.
Justice Sotomayor's majority opinion. In 1998, Texas charged Ruben Gutierrez with capital murder for his involvement in the killing of Escholastica Harrison. The state's theory at trial was that Gutierrez wielded one of the 2 screwdrivers used to stab Harrison to death in her mobile home. The jury convicted Gutierrez of capital murder. At the sentencing phase of Gutierrez's trial, the jury was required to answer whether Texas proved beyond a reasonable doubt that Gutierrez actually caused Harrison's death, or, if not, that he intended to kill her, or anticipated that a human life would be taken. The jury answered yes, and Gutierrez was sentenced to death. For nearly 15 years, Gutierrez has sought DNA testing of evidence he claims would prove he was not in Harrison's home the night of the murder. Texas's Article 64 allows DNA testing where a convicted person establishes by a preponderance of the evidence that he would not have been convicted if exculpatory results had been obtained through DNA testing, among other criteria. Invoking Article 64, Gutierrez twice moved in state court for DNA testing of untested crime scene evidence. The trial court denied his first request in 2010, and the Texas Court of Criminal Appeals, TCCA, affirmed. The court reasoned that even if Gutierrez's DNA was not found on the tested items, that would not establish his innocence of capital murder, because he would still be a party to the robbery that resulted in Harrison's death. The court concluded that Gutierrez could not use Article 64 to show he was wrongly sentenced to death unless he could also establish his innocence of the underlying crime. In 2019, Gutierrez again sought DNA testing, but Texas courts denied his motion. On appeal, the TCCA reiterated that DNA testing was not available to show only death penalty ineligibility. Gutierrez then filed suit in federal court under 42 U.S.C. Section 1983 against Luis Saenz, the district attorney who has custody of the untested evidence. Gutierrez argued that Texas's DNA testing procedures violated his liberty interests in utilizing state post-conviction procedures. The district court agreed and granted declaratory relief, finding it fundamentally unfair that Texas gives prisoners the right to challenge their death sentence through habeas petitions, but prevents them from obtaining DNA testing to support those petitions unless they can establish innocence of the underlying crime. The Fifth Circuit vacated the district court's judgment and held that Gutierrez lacked standing to bring his section 1983 suit, finding that his claimed injury was not redressable because a declaratory judgment would be unlikely to cause the prosecutor to reverse course and allow testing. 93 F 4th 267272 held. Gutierrez has standing to bring his Section 1983 claim challenging Texas's post-conviction DNA testing procedures under the Due Process Clause. A. Individuals convicted of crimes in state court have a liberty interest in demonstrating their innocence with new evidence under state law. For that reason, a state-created right to post-conviction procedures can sometimes create rights to other procedures essential to realizing the state-created right. In Skinner v. Switzer, the court held that a Texas prisoner could file a due process claim under Section 1983 against a prosecutor, where the prisoner alleged that the prosecutor's refusal to turn over evidence deprived him of his liberty interests in utilizing state procedures to obtain reversal of his conviction or to obtain a pardon or reduction of his sentence. The court reasoned that while the prisoner could not challenge in federal court the state court decisions denying his Article 64 motions, he could allege in a federal Section 1983 action that Article 64 unconstitutionally prevented him from obtaining such testing. The question of a state prisoner's standing to bring a due process claim against the custodian of his evidence was first addressed in Reed v. Goertz, where the court confronted another challenge to Texas's post-conviction DNA testing law. Reed alleged, among other things, that Article 64's chain of custody requirement was unconstitutional and effectively prevented many individuals from obtaining DNA testing. The court held that Reed had standing to pursue declaratory relief. First, Reed adequately alleged an injury, denial of access to the requested evidence. Second, the state prosecutor caused Reed's injury by denying access to the evidence. Finally, if a federal court concluded that Texas's post-conviction DNA testing procedures violate due process, the state prosecutor's justification for denying DNA testing would be eliminated, thereby removing the barrier between Reed and the requested testing. The same is true here. Like Reed, Gutierrez alleges that the local prosecutor's denial of his DNA testing request deprived him of his liberty interests in utilizing state procedures to obtain an acquittal or sentence reduction. As in Reed, the declaratory judgment Gutierrez seeks would redress that injury by changing the legal status of the parties and eliminating the state prosecutor's allegedly unlawful justification for denying DNA testing. B. The Fifth Circuit recognized the clear parallels between this case and Reed, but distinguished the cases, reasoning that the local prosecutor in this case was unlikely to allow testing, even if a federal court declared that Texas may not deny DNA testing that would affect only the punishment stage. Respondents, too, argue that Gutierrez lacks standing because the district court's reason for declaring part of Article 64 unconstitutional was only one of several independent state law grounds supporting the prosecutor's decision to deny access to the evidence. But this attempt to distinguish Reed fails twice over. First, to the extent the Fifth Circuit based its assessment of redressability on the declaratory judgment the district court later issued, rather than Gutierrez's complaint, it turned the Article 3 standing inquiry on its head. Gutierrez's standing does not depend on the relief the district court ultimately granted on the merits. The proper focus of the standing inquiry is the complaint, and Gutierrez's complaint challenges not just Article 64's limitation to actual innocence claims, but also the other barriers Article 64 erects between Gutierrez and DNA testing. Second, and more fundamentally, the Fifth Circuit erred in transforming the redressability inquiry into a guess about whether a favorable court decision will ultimately result in the prosecutor turning over the DNA evidence. In Reed, the court reasoned that if a federal court concludes that Texas's post-conviction DNA testing procedures violate due process, that court order would redress the injury by eliminating the state prosecutor's reliance on Article 64 as a reason for denying DNA testing. The same is true here. A declaratory judgment in Gutierrez's favor would redress his injury by removing the allegedly unconstitutional barrier, Article 64, erected between Gutierrez and the requested testing. The court in Reed was unmoved by the prosecutor's assertion that a declaratory judgment would not change his ultimate decision to turn over the evidence. The reason is simple, that a prosecutor might eventually find another reason to deny a prisoner's DNA testing request does not eliminate the prisoner's standing to argue that the cited reasons violated his rights under the Due Process Clause. C. Respondents also assert that this case is now moot because the state prosecutor refused Gutierrez's DNA testing request even after the district court issued the declaratory judgment. That claim fails too. A procedural due process claim like Gutierrez's is not mooted by the defendant's mid-appeal promise that regardless of the lawsuit's outcome, the ultimate result will remain the same. Holding otherwise would allow defendants to manufacture mootness by ensuring that no matter what procedures a court requires them to employ, the same substantive outcome will follow. Article 3 requires no such result. Reversed and remanded.
Justice Barrett's concurring opinion. When the Fifth Circuit attempted to distinguish this case from Reed versus Goertz, 598 U.S. 230, 2023, it failed to consider the breadth of the relief that Gutierrez requested in his complaint, see ante at 9. I would reverse on that basis alone. The court goes further, borrowing from our somewhat relaxed redressability inquiry in administrative law procedural injury cases. By invoking Atkins and Lugin in the unique context of requests for DNA evidence from Texas prosecutors, the court muddies the waters of standing doctrine. I respectfully join all but Part 2, B2 of the court's opinion.
Justice Thomas's dissenting opinion. I join Justice Alito's principled dissent because I agree that Ruben Gutierrez lacks standing to bring a federal suit alleging that Texas's post-conviction DNA testing procedures violate due process. I write separately to emphasize that this court has no business intervening in this case in the first place. The Constitution does not require any state to establish procedures for state prisoners to challenge the validity of their convictions after trial. Yet Gutierrez's suit rests on the premise that the 14th Amendment's due process clause gives him a liberty interest in Texas's voluntarily created procedures. That premise cannot be squared with any principled reading of the due process clause. The 14th Amendment does not protect Gutierrez's asserted liberty interest. As originally understood, liberty in the 14th Amendment likely referred only to freedom from physical restraint. It did not include entitlements to government-created benefits. This court's contrary precedent stems from a conscious policy-based rejection of the due process clause's original meaning. The original meaning of liberty in the 14th Amendment was likely far narrower than our precedents currently hold. The term originally appears to have referred only to freedom from physical restraint. When the 14th Amendment was adopted in 1868, its due process clause was understood to embody an old sea principle dating back to Magna Carta. Liberty in the Fifth Amendment likely refers only to freedom from physical restraint. If the Fifth Amendment uses liberty in this narrow sense, then the 14th Amendment likely does as well. It was not until the Lochner era that this court adopted a broader understanding of liberty. During that period, stretching from 1897 to 1937, this court relied on the legal fiction of substantive due process to invalidate disfavored social and economic legislation by states. This court eventually repudiated Lochner's muscular version of substantive due process, at least for economic rights. But the court continues to treat Meyer's definition of liberty as authoritative. Gutierrez's claim of a state-created liberty interest in obtaining post-conviction relief is inconsistent with the original understanding of liberty. From the founding through the Lochner era, liberty was understood to be a natural pre-political right. Such an understanding is fundamentally incompatible with a right bestowed by the government. In short, entitlements established by the government cannot be liberty under the Due Process Clause of the 14th Amendment. Gutierrez thus has no liberty interest in Texas's state-created right to post-conviction relief. Gutierrez rests the legitimacy of his due process claim on Osborne, which concluded that a prisoner has a liberty interest when state law gives him an entitlement to prove his innocence even after a fair trial has proved otherwise. But Osborne did not base this conclusion on the original meaning of liberty in the 14th Amendment. It instead relied on a line of cases ultimately tracing back to Goldberg versus Kelly, where this court relied on policy considerations to redefine property to include government entitlements. This court embraced Reich's vision in 1970, holding that welfare benefits are property under the 14th Amendment's Due Process Clause because they are a matter of statutory entitlement for persons qualified to receive them. Soon after Goldberg's radical redefinition of property to include government-created entitlements, this court redefined liberty along similar lines. Osborne thus cannot support Gutierrez's asserted liberty interest. We may, consistent with the judicial power, defer to earlier decisions that apply traditional tools of construction and arrive at different but reasonable interpretations of legal texts. But Osborne rests on nothing more than Goldberg's abandonment of the Due Process Clause's original meaning. We should correct the error we made in Osborne, which seriously undermines states' interests in finality and in providing relief to compelling claims of actual innocence. At the very least, we should cease finding novel ways to revive due process challenges to post-conviction DNA testing procedures, as the court does today. By recognizing a liberty interest in Texas's post-conviction procedures, however, this court has converted those procedures from a means of vindicating compelling claims of actual innocence into a tool for obstruction. 26 years after the brutal murder of Escholastica Harrison, this court stayed Gutierrez's impending execution. Why? Not because Gutierrez had made a compelling allegation of innocence. Rather, the court stayed the execution to decide whether Gutierrez has standing to raise a due process challenge to Texas's post-conviction procedures. Gutierrez's suit rests on a non-existent liberty interest. The Due Process Clause protects an individual's natural liberty from government interference. It does not guarantee entitlements to government benefits, like Texas's voluntarily adopted post-conviction procedures. By intervening to revive this suit, the court facilitates precisely the unjustified delay that it is supposed to prevent in capital cases. That is a misuse of our discretionary certiorari jurisdiction. I respectfully dissent.
Justice Alito's dissenting opinion. The court and I agree on one thing. We should decide this case based on the test adopted in Reed versus Goertz. After that, however, the majority veers sharply off course. First, it blatantly alters the Reed test. Second, it then has the audacity to criticize the Fifth Circuit for applying the real Reed test. Third, it ignores critical differences between the situation in Reed and the situation here. Fourth, it paints a misleading picture of underlying facts in Gutierrez's decades-long litigation campaign. Fifth, it fails to recognize the limited scope of the declaratory judgment at issue. And sixth, it ignores lawful and binding Texas law regarding the facts that may be considered when a prisoner seeks DNA testing. Because the majority paints a misleading picture of the facts and prior proceedings in this case, I begin by setting the record straight. In 1999, Gutierrez was convicted and sentenced to death for the brutal murder of Escolastica Harrison, an 85-year-old woman who lived in a mobile home park in Brownsville, Texas, with her nephew Abel Cuellar. When Gutierrez heard this, he hatched a plan to break into the mobile home and steal the money. By the time they left the scene, Harrison had been beaten and stabbed 13 times in her face and neck with 2 different instruments.
The end of direct appellate review was just the start of a new litigation saga spanning 23 years and counting. After the conclusion of direct appellate review in 2002, Gutierrez filed multiple petitions for state and federal post-conviction relief, none of which has been successful. At trial, however, his counsel declined to request DNA testing. As recounted by the TCCA, the record affirmatively shows that DNA testing was available to appellant before trial, but defense counsel apparently did not have testing performed on those same items because of sound trial strategy.
The Fifth Circuit faithfully applied this test in its decision below, taking into account the particular facts of Gutierrez's case. It noted that the TCCA has repeatedly held that Gutierrez would still be responsible for the murder under the law of parties and would still be death penalty eligible, even if DNA testing provided the results he wanted. And it thus held that a decision in Gutierrez's favor on his constitutional claim would not make it substantially likely that the district attorney would release the items for testing.
Today's decision, in contrast, flagrantly distorts the standard that Reed articulated. Indeed, the majority edits Reed's critical language in a way that would draw rebuke if done by an attorney in a brief filed in this court. The majority's analysis is based entirely on the first sentence, which states, if a federal court concludes that Texas's post-conviction DNA testing procedures violate due process, that court order would redress a prisoner's injury by eliminating the state prosecutor's reliance on Article 64 as a reason for denying DNA testing. But the majority pretends those sentences do not exist. This distortion is bad enough, but to make matters worse, the majority then criticizes the Fifth Circuit for transforming the redressability inquiry into a guess as to whether a favorable court decision will in fact ultimately cause the prosecutor to turn over the evidence. The majority's new test makes a hash of redressability. It appears that, under this new test, the likelihood of redress is simply not relevant. That most certainly is not what Reed held. The Texas courts have provided 3 reasons why Gutierrez is not entitled to the testing he seeks. Any one of these, if sound, would justify the denial of testing. Contrary to the majority's suggestion, a favorable declaratory judgment respecting the first of these reasons would not remove the barrier Article 64 erected between Gutierrez and the requested testing. It would remove a barrier. The majority treats this case as indistinguishable from Reed, but that is not correct. An examination of the situation in that case provides a clear explanation for the Reed court's conclusion that its test for redressability was met. And once that is understood, it is clear that the present case is different. Once the role that the chain of custody rule played in the TCCA's analysis is understood, the support for this court's redressability finding in Reed is easy to understand. The declaratory judgment that Reed sought, striking down the chain of custody rule, would have critically undermined the TCCA's holding with respect to the potential impact of DNA testing. 21 additional items, including the belt, could have been considered. Gutierrez's case presents a far different situation. Here, the TCCA has held that even if DNA testing failed to detect Gutierrez's DNA and detected the presence of Cuellar's DNA, Gutierrez could not establish that he was not guilty of murder or that he is ineligible for a death sentence. Thus, a favorable decision on Gutierrez's constitutional argument would not bolster his challenge to his sentence. This decision's only practical effect will be to aid and abet Gutierrez's efforts to run out the clock on the execution of his sentence. And if the decision is taken seriously as a precedent on Article 3 standing, it will do serious damage. I therefore dissent.
Case implications. All right, those were the majority, concurring, and dissenting opinions. Let's talk case implications. Gutierrez vs. Saenz creates a notable expansion in federal court accessibility for death row inmates challenging state DNA testing procedures. But the decision's broader impact remains uncertain given the sharp divisions among the justices. The majority's ruling effectively lowers the bar for establishing redressability in Section 1983 suits against prosecutors, potentially opening the door for more federal litigation challenging various aspects of state post-conviction procedures. However, Justice Barrett's concurrence signals important reservations about this approach, warning that the court has muddied the waters of standing doctrine by borrowing from administrative law principles in this unique DNA testing context. Her pointed criticism suggests that even some justices in the majority coalition have concerns about how far this precedent might extend beyond its specific factual circumstances. The dissenting opinions reveal deep philosophical fault lines that could influence future cases involving state-created procedural rights. Justice Thomas's originalist critique goes to the heart of modern due process doctrine, arguing that the entire framework of state-created liberty interests lacks constitutional foundation. Meanwhile, Justice Alito's technical dissent focuses on what he sees as a dangerous weakening of Article 3 standing requirements, warning that the majority's approach could do serious damage to federal court jurisdiction principles. These competing visions, between expanding federal oversight of state procedures and maintaining traditional limits on federal intervention, suggest that future cases involving similar procedural due process claims will likely face continued judicial scrutiny and potential doctrinal revision, particularly if the court's composition shifts or if justices reconsider the balance between state sovereignty and individual rights in the post-conviction context. And thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Up next, Riley v. Bondi. Talk to you soon.